Hello, everyone. I'm Hoyt Kesterson. I'm here today about about being an expert witness. And joining me is my co-speaker, Lauren Toppelson, who's a real lawyer. So let's get into this. I'm not a lawyer, obviously. So I'm a technical folk. People who've seen me at this conference for a long time know that I'm not a lawyer. So what's this about an expert witness? I have a very favorite movie. It's called My Cousin Vinny. And I like it so much because it shows exactly what an expert witness does. And I'm not the only person who thinks that, because this film is actually shown by college professors at real law schools, real good law schools, as an excellent example of how an expert witness is used and brought into a court case. So if you've never seen My Cousin Vinny, it's also a very great movie. The lady sitting to your left won an Academy Award for it. And
not me.
To the left of the picture. Anyway, so what happened? Well, in March 2019, the Arizona signed a law called the Dealer Management System Law, which basically mandated that a particular sector of industry, an industry that actually services automobile dealers, had to give access to their product by offering an open API. Okay. Many people have argued that these companies, they're only really two big ones. They buy everybody else, have almost monopoly on it. And the car dealers are never very happy because even though they put their data in, they really can't get to it the way they wanted to. And so several states have been considering all kinds of different actions, but Arizona took this different approach, said, let's mandate an open API. Well, those two companies took umbrage, and they actually said, we're suing you. We're suing the state of Arizona. And interestingly enough, I became an expert witness. And so on June 3rd in 2020, I had the unusual experience of being in a witness stand. I've been in one of those before, but it's the first time I've ever been in a witness stand wearing a mask. So that was pretty interesting. Now, I've done this 4 or 5 times, 6 times throughout my career. This is not things I go looking for. But a lot of people ask me, okay, well, how did you get this gig? And in reality, it started with a phone call. A long time ago, I was sitting at my desk, and out of the blue, this phone rang. I answered it, and it was this attorney. And he said, what do you think about a patent on a directory service to store X509 public key certificates? And I went, well, that's interesting. I led a group that published the international standard about that. Of course, that's why he called me. And he basically said, I hoped that you would say that. Would you be willing to tell a court that? And so that was the very first time I ever got into this entire issue of preparing to be an expert witness. Now, interestingly enough, I did a lot of the first stages of it. Worked on writing a document, so forth, that said this is why this should never be a patent. And in fact, that's what finally happened. The people withdrew the patent, but I didn't really get to court. And you'll find that out as an expert witness. A lot of times you do things, and lawyers rather settle. They don't want to go to court, right? And so if you write a compelling enough story or do a compelling enough story or add enough compelling facts to an argument, you may find that you're not going to go to court. But I have actually been to court several times too, typically when the bucks are big, okay? So what exactly is the different kinds of witnesses? And I'm going to tell you from my level, which is not a lawyer, right? So the fact witness, hey, it's an obvious name. They basically testify to facts that are based on the direct observation of events. In other words, they were involved with them. They did them. They saw them, or they were standing right there and they heard something, right? It can't be second degree. It can't say, Bill told me this happened, because you've heard this term. It's called hearsay, right? So fact witnesses are they're observing the fact. That's why they're easy to remember. Sometimes in legal documents, you will see them referred to as lay witness, L-A-Y, but that's it. An expert witness is not involved in the case events. This is an important point, not involved in the case events, because you can be an expert and be a fact witness. In fact, the mock that's coming up at the end of the day, what the person who would normally be an expert witness is actually testifying about the assessment they did. And so, hey, it's not opinion. It's, it's not explaining. They're actually explaining facts about the case. So even though the person is an expert, they are in fact a fact witness, and that's allowed. Okay. One of the important things about it is if you're a fact witness, you're not supposed to be getting paid for it. So along that line. The purpose of an expert witness, especially as things gotten more technical, is they're supposed to be able to explain technical details to attorneys, the judge, and the jury. That's their major thing, explaining what in the world's going on. Well, okay. Now that sounds all very straightforward. How could this get messed up? Well, it gets messed up over the question that you might ask yourself. Well, what makes you an expert? How come you're an expert? And that happened a lot, particularly in the 70s and 80s, because people would be dragging experts out from the strangest places, often under the strangest drugs. And so effectively, there's this thing called Daubert, which I'm not going to talk about because I'm not an attorney. But Ms. Toppelson is.
Hi, everyone. Thank you for joining us. So, yes, I am an attorney. I don't have an opinion about that at the moment. I do want to talk about experts, though. I would like to just back up a little bit about what Hoyt said in terms of what the role of the expert is, because an expert can be engaged in a number of different roles. As Hoyt pointed out, a lot of them do not go to court and testify. So an attorney may engage an expert to further educate themselves on something. But in terms of offering an opinion, which is a matter of why they would go testify in court or in a hearing of some sort, they have the old adage about everybody has an opinion, sort of like shoulder blades. Well, not everybody can offer an opinion in court. So the expert's opinion, the question is, are you an expert? And then the question is the opinion something that can come into court? And the judge acts as the gatekeeper. So there's jury trials and bench trials. And a bench trial means that the judge, typically in a jury, let's start with a jury trial. And typically the judge will make conclusions of law and will decide those issues of law. And it's the jury who will determine issues of fact. And that's the typical division of labor, so to speak. If you have a bench trial, there is no jury. So the judge will do both. He'll make determinations on the issues of law and on the issues of fact. And I mention this because the judge is always the gatekeeper in terms of what opinions can come in and whether somebody's qualified as an expert. So the first thing is someone qualified? And the main question is, and we're really relying on the federal rules of evidence because state law has its own evidentiary rules, and the federal rules are the ones that all the federal courts apply. Under the federal rules, which is Rule 702, an expert an expert opinion is admissible if the expert has a certain scientific or specialized knowledge that would assist the trier of fact, which could be the jury or a judge, if it's a bench trial, to determine an issue of fact. They're not really supposed to go to the final conclusion. They're certainly not supposed to offer an opinion on a legal conclusion or the ultimate determination. And this is where parties start to tend to fight a little bit in court about whether the expert opinion is testifying or offering an opinion, intends to offer an opinion to the ultimate conclusion that the jury is supposed to determine, because you don't want to invade the province of the jury or the fact finder. And that's where a lot of showdowns go. And there are these things called motions in limine to preclude an expert from testifying. So that's what will get the expert in. The next question is, what about the nature of the opinion? And Hoyt mentioned the Daubert factors, and that's based on a U.S. Supreme Court case called Daubert versus Merrill Dow. And it sets up 5 main factors that a court will balance to determine whether an opinion should come in. And those factors include whether the nature of the opinion is something that's scientifically generally acceptable in the community. The next is it something that can be tested? Are you offering an opinion on a matter that can be tested and proven over and again? And if so, what's the known error rate? Is there an error rate? Is it something that's been subject to peer review, publication? Is it repeatable? Are there control standards? So those are the 5 Dauber factors. And based on that and the qualifications of the witness, the judge will determine whether or not the opinion will be allowed.
Well, it's interesting that you said that scientific, because is it not true that over the years it's been broadened to be more than just scientific, business,
Yes.
Business, or even business or technical? So, for example, I understood that you could, for instance, be an expert on real estate values, for example.
Absolutely. Any kind of technical or it's sort of a unique knowledge. And real estate values is a really good one. If somebody's very familiar with the real estate in a certain area, and whether it's commercial or residential and has been in that area, it's not something that they can study. Perhaps it is something they could study immediately for that matter. But it is something that they have a history and education in, they've written in, they have some kind of higher degree in. Not always a higher degree is not necessary, but some credential.
Some credential is nice. The search for a lawyer is interesting. I met Lauren a long time ago because I met her because I became her expert witness. I was heading to Florida Keys for vacation, and I spent an incredible amount of time. Now, I must admit that I was sitting in the sand outside of the little bar that was used to film Key Largo, talking on the phone to Lauren, who was sweating in an office in New Jersey that for some reason had no air conditioning. So it was a little bit more enjoyable. But this case is probably a good bad case about, hey, how to get an expert really quickly. And we're not doing anything at the normal measured pace that you find in terms of preparation for a trial. So, Lauren,
Sure.
the search for an expert in the case of the rhino with no clothes. Head out.
This was an unusual case that my biggest mistake was accepting it as the third attorney who had been on this case. And I was told that a hard drive had been, and they used the term mirror image, a mirror image had been made of this hard drive. And as it turned out, it hadn't been. It wasn't a mirror. It wasn't a forensically sound image of this hard drive. And the case involved a software product liability issue with competitors and a potential backdoor that allowed competitors to get the information. It was accounting software specifically for the pornography industry. So that's why the rhino had no clothes. And it wasn't easy to find an expert. First, I had to find one in very short notice because once we had engaged in I had come to some agreement with my adversary about a protocol to look at this hard drive. The initial step was open it up and see what's on it, since nobody had any idea what was on it. We found out that it wasn't what it was purported to have contained. So they yelled spoliation, that I hadn't, or my clients hadn't preserved relevant data or documents or information. I won't get into that because that was really the punchline of the case. And the judge said, when the attorneys were both arguing about what had been asked for and what had been preserved and what other efforts had been made, the judge literally said, it sounds like a bunch of attorneys talking about technology that they know nothing about. I want you and your experts in my courtroom in 10 days to testify to what this is. Well, so my experts, I didn't have an expert. I didn't make that image. I hadn't retained the party who had made the image. I had inherited this hot potato and I needed somebody. And the first expert I found who had very good credentials, when he found out it was, he had another job working, he had a part-time job working for, as it turned out, the Archdiocese. And when he heard the nature of the case, he felt like he couldn't take it. So yes, Hoyt came on second on my he was the second person, but he wasn't my second choice. He just happened to be the second person.
Yeah. And when I was asked what did I think of it being porno? I said, well, personally, if it weren't for porno, I didn't think we'd have VCRs. So I didn't really have a problem with it, And besides which, the case, as you said, was an accounting case, a programming case. It really didn't matter what industry it was in, although we did meet some pretty unusual people associated with it. So
you should see some of the exhibits.
so that was kind of fun. So that's what happens when you're in a panic. But if you're not in a panic, Lauren, what do you want in an expert witness?
Well, this is not all about your resume. A good resume alone isn't going to do it. You really want somebody who's likable. You want somebody who the jury's going to like, the judge is going to like, somebody they're going to have confidence in, somebody who inspires trust. You want somebody who basically the resume is helpful and necessary to qualify the expert, but that alone is not going to do it. You want somebody that you probably want to spend time with. And it's unusual about what you don't want. It's almost easier to figure out what you don't want.
What don't you want?
Well, you don't want somebody who's going to condescend to anyone. You don't want somebody who's verbose. You don't want somebody who's unclear, who can't get across a thought in a clear way. Lawyers in law school who want to become trial lawyers tend to take trial classes. I know I took several. And one of the things that we learned was you never know what the jury is going to pick up on when somebody's testifying. And that's particularly true of an expert. You hold somebody up and want the jury to accept this person as an expert. And what is the jury going to focus on? Is it the expert's fancy pen? Is it some big ring the expert's wearing? This is something that you really want to avoid. So you want somebody that the jury is going to like, and no chewing gum, not somebody who's going to sit up there and pick their nose, not something like that. You really want somebody who's professional and comes across that way.
And of course, once you've picked this thing, I always remember going back to the very first attorney that I worked with, and we worked in his office off and on for a while. And like I said, I never got to court, but he said, you know what I like about you as an expert witness? And I said, no, what? He says, you answer only the question asked. He talked about sometimes you get an academic and the academic's really knowledge,able and the academic is so used to teaching and so used to explaining that when the opposing counsel would ask a question, the academic might say, well, you're not really asking the right question. You really need to ask. In other words, this is not what you want your expert doing for opposing counsel. So it's interesting. Even though you may know a lot of stuff, even though you might truly be an expert, you're really in two realms. You might have someone who presents themselves really well, but doesn't know the topic that well. That can happen. But the other is just as likely. I know the topic really well, but I don't stand a chance of explaining it. Or if I do, people hate me when I'm done. So.
Right. Even in our case, you caught a mistake on the part of the other expert, which was important and something that we could use on cross. And yeah. I'm sorry, why don't you speak to that?
Yeah, well, it's just that this was a classic example of a very young man who was hired to essentially do all the data extraction, work for the data extraction, and so forth and so on. But he didn't really have a detailed understanding of the operating system. And in this particular case, that operating system was Linux, right? And so this was kind of a Windows guy. And as a result, when you get into arguments about what should or should not be, or what is or is not in an operating system, your breadth of knowledge should be somewhat more than, hey, I've been running on Windows for the 5 years of the life I've been working in the industry. So it was that kind of thing. It's we'll talk about that when we get to the end, but to me, it's really important that, you can be really good at your job, a way of doing it. But in reality, if you're an expert in your job, pretty much all the ways of doing it and when you should do one or the other. And that's kind of the big difference. So there are some legal terms, right, that I learned, okay, because I had no idea. Even watching Perry Mason, I don't think I ever heard one of these terms. And I know that the first time a lawyer ever said to me spoliation, I said, "Don't you mean spoliation?" And he's, "No, spoliation." And so this was a learning exercise for me. But I believe that particularly if you're a technical person like I am, these are three very important legal concepts you need to understand. And Lauren is going to graciously explain them to you.
Well, discovery is the process in a litigation whereby both sides sort of have to exchange information regarding their positions, whether it's an offensive position or a defense. And there's some mandatory disclosures that have to be made according to the federal rules. And then there's other disclosures that you can ask. You can ask interrogatories or questions. You can ask for documents, or in this, people refer to documents sort of generally, but it's documents or data or an inspection of something. So you want to see what the other side has. Maybe documents will support their case, but if they have an item, you want to inspect it. But we are trying to stick to technology-based information. So software, you might want a copy of the software to try it out, actually. So each side, so that you go in, discovery is intended to avoid surprise at the end. So trial is not supposed to be no, I got you kind of experience. You're supposed to know little bit about what the other side's cards are and what your card, and they're supposed to know what cards you have. And by the time you get to trial, it's a battle of the facts and the issues, not a matter of surprise. So that's the discovery process. And it involves also depositions, which can involve a deposition of your expert. You have to disclose that you've hired an expert. If there's an opinion, if your expert has issues an opinion, you need to share it with the other side. They get an opportunity to hire a rebuttal expert. Not that they need to, but it's typical. I actually received an expert opinion from my adversary, which I thought was so favorable to me. That was the opinion I was going to rely on. I had no intention of hiring an expert. I was going to use theirs. It's interesting how an expert opinion can work out for you that way, but it doesn't happen too often. Sorry, go ahead.
So in discovery, not everything can be discovered, right? I mean, because there are certain communications, certain things which can't be discovered.
Well, everybody's most familiar with the attorney-client privilege.
Well, not everyone. That's why we're talking about
I'm sorry. Okay. Well, most people who've watched any kind of TV, Law and Order type show probably knows that one. And that privilege can extend to the expert if the expert is acting as an agent of the attorney. So in other words, the expert falls within the same umbrella. Doesn't happen always. And that can be a battleground area. More regularly, what does happen is work product privilege when it relates to an expert, because the expert can present some kind of analysis, perform some kind of study, and, as I said, render an ultimate opinion on what the conclusion is regarding the issues that he or she has been reviewing, the matter that he or she has been reviewing. And that's another battleground area, whether yes, the expert opinion is something that's discoverable. What about drafts? What about communications with counsel? What about that can get very thorny. There are fights about that. It's not as clear cut. And so you really want your expert to refrain from putting anything in writing until you finally have a good sense of what it's going to say.
Well, it's not exactly as it used to be, because I remember that, I mean, they changed the federal laws on this one, but not necessarily all the state laws are kept up. But I remember when I first started doing this, that if you had multiple drafts of your expert's report, those drafts were discoverable. And so we would go to a great effort and this, considering back when I was doing this good stuff, this was sometimes hard to do. I would have exactly one copy. I would not even do backups of it, which was always a frightening thing to me, because God help you if you lost it, right? But if you had a backup, that's another copy. And the point here is that they're going to, if you have multiple copies and they see a difference, they're going to say, well, why did you change your mind here, right? And so we go to great effort to have exactly one copy. I would sit there and write a draft, and I wouldn't send them the draft or anything like that, because that would be a copy. We would somehow get together, either via shared screen or sitting in the same room, and they would read over my shoulder and make recommendations, and I would make changes. And the law actually changed that and made that work product privilege, which made life, made that work product protected, which has made life easier. But if you guys hang around in the law track, you're going to find the mock trial at the end of this, at the end of the day, is actually talking about a big legal kerfuffle over whether or not a forensic examination by an expert is really a privileged document or not. And there have been some really big cases on this lately. And I believe that another panel is talking about this topic also. So it can be really important. Let's go down to the one that I always used to mispronounce. Let's talk about spoliation. What is spoliation?
Well, that is a term that has really grown in popularity over, I'm trying to remember the first Zubelik case. I'm referring to a case out of the Southern District by a Judge Shira Shinlin. And she's sometimes considered the mother of e-discovery in some sense, or at least in terms of standards for spoliation. She was the first one who probably articulated best that, spoliation is failure to preserve evidence that potentially and could be relevant to your case or the other side's case. And when does that duty to preserve arise? And she was the one who articulated in terms of when you have a reasonable expectation of litigation, that's when the duty kicks in. So it's not the day that you get served a summons and complaint. It's not the day that the process server is ringing your doorbell. It's not the day that you get a demand letter. It tends to start before that. If you have a reasonable expectation, if an employee throws up there, if you terminate an employee and the employee turns around and says to you, I'm going to sue you for everything you've got, that's a reasonable expectation of litigation. You need to start preserving information relating to that employee's employment with you. So spoliation is the failure to do that.
And it can be both. It can be both either accidental or purposeful, right?
Yes. The federal rules have been amended to deal with electronic information, but spoliation can also apply to any kind of evidence. So I had a case where there was a biking accident, and the woman who was widowed was going to have the police throw out the bicycle, which would have been not helpful for her case as well. She wanted to prove that her husband hadn't had a heart attack, but had been hit by the car. He had a heart attack ultimately, but she wanted her position was it was caused by the accident, not that it preceded the accident. Anyway, so the point is that it can apply to any evidence, and the federal rules have rules that govern what happens if you have failed to preserve evidence, particularly digital evidence or electronic evidence. And if it's not intentional, but it's prejudicial, the judge is empowered to mete out a remedy that is commensurate with the prejudice to the party who would have wanted to present that information. Well, it's really the other side. So if I've destroyed my own evidence, I can't now go ahead and say this is what it would have said. The benefit is to the other side in that equation, always in this equation. If it's intentional, if a party is found to have intentionally destroyed evidence or failed to preserve evidence in an effort to deprive the other side of that benefit of that evidence, then there's a number of sanctions that the courts have recognized in common law and which are now also stated expressly in the federal rules. And those include anything from the court can instruct the jury that they should assume that the evidence would have been beneficial to the other side, and that they should adopt what's an adverse inference, that the the evidence that's been spoliated would have inured to their benefit. It can even go as far as having a default judgment entered against the spoliator, or to have a case dismissed against the spoliator. So those are real extreme examples, but they do happen. But you need to be able to show prejudice no matter what. That by being deprived of this information, you suffered prejudice.
There are two interesting technical things here that I think people should consider. A lot of people at this conference, for example, would be responsible for someone's data retention, data destruction policy. And as Lauren has said, if you think that you're going to be hit with a lawsuit or something along this line, you need to actually stop your regularly scheduled data destruction. And the other interesting issue is encryption. So I actually had a case where data that the plaintiffs wanted to see had been as part of the regular process encrypted a long time ago when it happened. And guess what? They had lost the keys, and their key escrow system had kind of messed up. It was all accidental, but that's kind of like what I had to prove. So what do experts do? Well, let's go to Lauren's first thing, where the first case she talked about, where the data production was all messed up. That was a classic example of someone who thought it was a good idea to take a Linux data dump and convert it to Windows, to help the lawyers, which of course destroyed all the metadata. It was an innocent, helpful kind of thing, but it's exactly why experts should be involved when you're doing data production. They will examine physical things like bicycles, like bloods and stuff, everything you see on CSI. And you can even find people who will tear a disk drive down and use an electron microscope on it to recover something. So they do physical things. They do interesting things that are very specific to our software industry, like examine code. It is so easy to move code from, say, some program you saw and just put it in your program. Well, sometimes that's not exactly legal because of copyright and so forth. But what if you're clever? What if you change the tags? What if you do this? Well, then very clever people like this longtime colleague and friend of mine, they actually look at patterns and look at stuff and say, okay, well, yeah, but isn't this an interesting way? And programmers are funny. I mean, it's almost like a signature. Sometimes you look at code and you can actually say who wrote that because of the style of writing. And that becomes very useful in that case. Then there's the thing I mentioned is forensic investigation. That's becoming more and more important nowadays because we're seeing a lot of things that are happening because villains are breaking into your system. And it's just not your system crashing because you've written bad code. No, it's because you've written bad code and it let a guy into the door and he took everything and made a mess while he left. And so you need someone. The interesting thing about computers, well, here's where the body is, but where was it shot? Okay, so you have to go back and actually find the trail of blood to do that. And that's what forensic investigators do. And as you can imagine, lawyers are very interested in that because if they find that you didn't do a good job of securing your system, that's negligence. And that really helps in a law case. And then we get down to the really weird ones, which is opine on concepts. And the thing I did for the state of Arizona was exactly that, because it's all pretty much about, well, what is an API anyway, And an argument was being made on the other side that an open API has no security, which of course it does, but that was just kind of the argument. So you end up arguing on concepts, and these are kinds of things that you might find yourself doing as an expert. So you can find a niche and do what you need to do. So there'll come a point where you meet the attorney. You go and you meet Lauren. Okay, Lauren, what happens then?
Well, we interview. And as I said, we want to know if this is somebody who the jury is going to like, somebody you can spend time with, somebody who knows their stuff. And that's in the context of whether you're hiring an expert to examine something or to provide an ultimate opinion of something. I think one of the things that Hoyt had actually asked me to speak about was non-disclosure agreements. So the expert opinion, as I said, is something that gets produced, but there's information that you're going to provide the expert that they are going to rely on in forming that opinion. And it doesn't just even have to be in the context of an opinion. I provided a hard drive to a forensic analyst recently because the timekeeping program that my client used for his employees had corrupted. That's the short story. And we were trying to obtain whatever we could get off of the hard drive. We weren't able to go back. There were 6 years at issue. We were able to collect 4 of them, which was better than having no bullets at all, because that's what I felt like. I was going into a gunfight with no ammunition. So the point is that the hard drive obviously includes a lot of other information that may not be related to the case and or personal information regarding those employees. So you ask the expert to limit the scope of what they're reviewing and not to share the information with anybody else. Also, you don't want them to share their negative conclusion if they have one. So I hired, that was another incident where I was going to hire a handwriting expert. And I provided him with multiple copies of examples of this person's signature. The question was whether or not this person had signed the agreement, which my client said had been signed. And my expert did not put his opinion in writing. He was a smart expert. And he called me up and he said to me, he didn't say to me, this is important. He didn't say to me that this is not the signature. He said to me instead that I cannot testify that this is the signature, which means that I was free to go find another expert who could testify that it was the signature. And his opinion was helpful. Frankly, the case was settled in large part because of that. So Hoyt was talking about non-disclosure agreements. Those commitments to keep information confidential continue after your retention. So they often include requirements that in the event somebody tries to obtain the expert's opinions or the data that they may have been provided and still have, or their impressions, that the expert will notify the attorney who retained them in advance of disclosing any of that information, so that the attorney who did retain them can get involved if necessary to seek some sort of protection.
Okay. Now, then there's compensation. I found the interesting thing about compensation to be, hey, you know how normally salaries are secret? When you're an expert witness, your compensation is not secret. And so there are really 2 interesting things about it that I learned. Number one, it's not secret. When Lauren talked about how she had to tell the other party that an expert witness had been obtained, she has to tell them how much they're paying. What they're paying them. But also, when you write a report, it basically says, "Hey, I'm being charged X. I'm being paid at X dollars an hour, or maybe a fixed amount or something." And the second thing is your compensation cannot be based on result. In other words, it can't say, well, you'll get more money if we win this case, because that's kind of like saying, well, in that particular case, maybe I can shade it a bit because I'd like to make more money. So you're not allowed to do that. And of course, Lauren just covered non-disclosure agreements. It's very, very important because you're going to see all the sensitive stuff. And then you'll as the expert, you'll get it, and you have to protect it too, because we've seen several cases where people have been attacked by ransomware guys, and the information they found is the sensitive information that belongs to these people's clients. This is not good. And finally, you end up, and of course, you're retained. This contract is done. So what do? You're retained. Well, you're going to study that all these documents that you talked about coming in discovery. There's this thing, bury them in discovery. Sometimes they used to try to do that. That was a lot easier to do when it was paper, a little more difficult in electronic documents because you can use tools to do it. If you're an expert, Wikipedia and Google are your friend. But I always love that line, start with Wikipedia, but never stop there. And that's important. That's important, okay, because that shouldn't be your thing. I recommend that Wikipedia is really great, but not for the article itself. But most people don't even notice. That's pretty much at the end of every Wikipedia is this bibliography, the documents that the people who wrote the bibliography referred to. And that's a good source to go looking for things. Then you're going to write an expert report or declaration. And I was always confused about this for a long time, what the difference is. In a declaration, you're actually putting an opinion. In an expert report, you're just explaining things, and you never really actually say what all this leads to. As Lauren says, you're leaving it to the trier of fact to make a determination. But sometimes you're asked to opine, then it's a declaration. The other interesting thing you end up doing is that the opposing expert will have been deposed or written documents and so forth. And so you're basically, I always think the word rebut. Yes, it's because yes, but's kind of what you're saying. You basically help the lawyer come up with arguments against what the opposing expert is saying. And deposition. What can I say about deposition? Deposition is very exciting because you, the expert, are sitting there and you are the target of more eyes than you've ever been used to. You haven't lived into your room with 12 lawyers and a video camera and a court stenographer, right? And they're all looking at you. And the important thing about deposition is that it's all going to be recorded. It's all going to be examined. And whatever you say, they're going to turn around and give it to you in court. So you have to be very careful when depositions, what you say in deposition. And one of the other interesting things they'll ask you, they will have read your report and they will actually say, have you changed your mind about your report? Have you gotten any other information? And you should make that point now, because you don't want to actually say something later in court and testimony that then say, well, in deposition, you said something totally different. That's embarrassing for everyone. And of course, it may actually go to court, in which case you're going to testify direct. Direct should never be a surprise because that's your attorney. Okay. You're supposed to remember that practice. We're going to talk about it again. You've done this. You know what you're supposed to be saying. Cross. Well, this other attorney is going to actually try to weaken your arguments. And that's going to be difficult. That's the entire goal. And sometimes they can do this to be helpful. The thing I remember most is for this encryption case, I went and talked to the person who was the systems person at the time. And then the lawyer hopped in and said, and he told you what went wrong. And I said, no, he actually confirmed what I already thought was wrong. So you have to be very careful when a opposing counsel tries to be helpful for you and give you words. And then also sometimes you want to say yes, but on a question when they cross you, but don't. If it's important, your lawyer will note it and they will redirect and they'll ask you the questions that let you answer the right way. And of course, practice. You tend to do this all the time. So when we come down to what does an expert really do? Okay, well, Lauren said it, when she talked about whenever you hire an expert witness, an expert witness has to be able to explain. If they use terminology, if they use jargon, that's great in a conversation amongst experts, but it's not in a good conversation to the jury or the judge. The judge is going to be very educated, but not in your area. So you go. And of course, the most important thing, which I mentioned, is you tell the truth, but you only answer the question. You don't give them more truth than they've asked for, right? You let them work that out themselves because that's what they've got to do. So when you come down to what you must do, this is why I talk about teaching. You must be able to teach when you write and you speak. Well, how do you do that? How do you get to that point? You get there because you just write often. I don't care what you write or anything else on the line. And then you speak often. You give as many talks as you can. To get noticed, you volunteer. So for instance, talk at this conference, work at this conference, local conferences, right? And it's good to go where attorneys go, okay?
Find us at the bar.
Yes, that can be the bar after the conference too. That's really the great thing. And so what do? Well, you join organizations. I happen to be in the ABA Information Security Committee, which is really bizarre. I happen to be co-chair of it, which is even bizarre. And then there's InfraGard. I've spoken to InfraGard. It's the only audience I've ever spoken to where half of them were packing weapons. But still, you meet a lot of lawyers, you meet a lot of prosecutors, you meet a lot of lawmen, it goes along the line. So as Lauren mentioned, credentials are good. It's good to have. It's great to have a PhD or whatever else on this line. But if you can't talk about it, if you can't teach it, so you work on writing and speaking. I work with a lot of technical people. I see their stuff all the time, and they're smart, but they sure as heck can't write about it. So write a blog, an article, or if you're really adventuresome, and I'm not, I'd rather watch Buffy, write a book, okay? And then, like for this conference, but it can be local conferences, start out small. Submit speaking proposals to conferences, volunteer to speak at user meetings, okay? And then here's the most important thing if you're going to be good at this. Equanimity, a word I really like. In adversarial situations, sounds very complicated term, but the opposing counsel will try to get you nervous, will try to get you to say the wrong thing. And heaven help you if you get upset or angry. You can't let that happen because, as they like to say, it's not personal, it's just business. So where's the best place to learn that? Well, arguments over the Thanksgiving table with your uncle might work along this line, but probably the best way to do it is to find yourself on a panel to talk where not everyone on the panel agrees. And the second thing is to take a debate class where you learn to do this kind of stuff. Okay, so online.
Wait, something just popped up about joining InfoSec. You can do that by going to the ABA website and look for the Information Security Group, and it'll tell you where there's a slight fee to join, but it'll have all the information when they have meetings and what advantages there are to joining the group. It's a great group. It really is.
And the important thing to remember here, I mean, I worked with them for a long time without even realizing. I thought you had to be a lawyer to join the ABA. I mean, that makes sense, American Bar Association, right? But in reality, they have something called the associate membership. And so the associate membership is, in fact, for technical people who, for some bizarre reason, want to hang around with lawyers. And so it's
the reverse. The lawyers who want to hang out with the tech people.
Reason it might be. And for instance, the section that I'm in, and Lauren's also in, is called Lauren. You may also be in trial lawyers. I don't know, but because you do litigation. But there's a section called Science and Technology, and under Science and Technology, there's a privacy group. I think Steve Wu is in the audience. There's artificial intelligence and robotics. There's information security, which is the group in which I'm in, where we talk a lot about just information security and all the laws that have to do with it. You got a lot of things you can join there, but join as an associate if you're not a lawyer.
Somebody asked the question about somebody who looks like they've testified as an expert witness before, in depositions at least, and wants to know how to avoid, I can't see the whole thing. How do you manage, there it is. How do you manage your character assassination that can be used by opposing counsel to discredit you? Well, if it's character assassination, it shouldn't be going on because it's not supposed to be personal. So that shouldn't happen at all. And the attorney who's defending you should make sure that gets shut down. But if you're talking about the times where you may have opined in a different way or in a way that's contrary to what you're offering now, your position is, I would suggest that this makes me a well-rounded expert because I'm not committed to one position or the other. I can see it from both sides. And therefore, in this case, my opinion that it went left is particularly credible because I can see that it goes in both ways and have testified to going right in other instances. I hope that helps.
But it makes it tough for you. I was actually in a case, as the web and Google got better, I was actually in a case where the opposing expert, the attorneys I was working for, found an opinion that was diametrically opposite what he was saying before. And that's a lot easier to do now that everything's online. You can find all this good stuff. And he was kind of really shook up by that. And he really didn't, and no one had really practiced for that. But it can really hurt your reputation. As far as character assassination goes, I mean, it's as Lauren said, it's the responsibility of your attorney to not let that happen. It's what's called objection and all this other good stuff. But sometimes they do the weirdest things in the world. I did a case that had to do with open pit mining. Okay, now, I know nothing about mining other than the fact that the holes are awfully big. But the whole point was about mining equipment, these big, these things whose tires are 10 times your height, so forth along this line. And all these things are interconnected. The computer knows how much dirt is in this shovel and whether some loader can actually carry it or something. And so everything's all scheduled, it's all happening electronically. It's very, very fascinating stuff. And I was an expert witness having to do with this technology. But opposing counsel just kept objected to my presence because he's not a mining expert, even though I'm not a minor. Well, I didn't get bothered by that. I mean, it might be, you don't say yes, but, my counsel handled that argument. But still, at the very end, I still remember he was so funny. This guy was an amazing piece of work. First thing is that during deposition, I'll tell the story because of how deposition works. During deposition, which they made a terrible mistake and said, please tell us about your career. And I said, everything? And they said, yes. And 2 hours later, they said, oh, let's stop now. And so, because I've been doing this for a long time. But one of the things they noted was that when I'd actually stopped programming, because I haven't programmed for a while. And he said, well, they asked me, I could see the other expert whispering in his ear, do you write C code? And I said, well, no. I said, by the time I stopped programming, C was just becoming popular. But let me explain that I chair an international committee that's of a standard X509 that everybody in the world is implementing. And we get a lot of questions from people about how to do something in the standard. And a lot of times these questions are phrased as code, okay, which is C code. And I said, therefore I can read it, even though I can't program it. So anyway, but I didn't think too much of that. And so at the very end of the examination of me, he wrote on a piece of paper a C statement. And I remember I muttered under my breath, oh, a programming test. And the judge giggled. You never want the judge in supporting your expert like that. And then he wrote on a piece of paper the C statement. And then he asked me to explain it. Well, unfortunately from him is that I really did know C. And so I really could explain it. And they'd even cheated a little bit in terms of information, but I kind of guessed what it was. And when it was all done, the people I was working for said, well, we don't use that C statement. We don't use that particular piece of code. And I said, well, no. I said, I assumed that they expected you to coach me on everything that you used in terms of their API and their calls and so forth. You didn't, you haven't, we've not had that conversation, but they expected it. So that's why they did it. So, but the whole thing was, here's a test, here's a test that's doing that. And his entire purpose, his entire intent was at the very end of all my testimony, where I had been really arguing that you can look at statements, you can look at APIs and figure out what they're doing. You don't have to know the code that's behind it. The whole point of APIs is you don't know the code, but you know what it's supposed to be doing, that you could actually figure out what calls we're doing. And he wanted to destroy that. And that's how he chose to do it. And that's what I mean about the fact that, well, see, now I don't call that dirty fighting. He didn't say I was lying or anything like that, but he put me to a test, and he put me to a test, a really, really clever test, which I passed with flying colors, unfortunately for them. But it's just the way attorneys are. You have to realize the other side is being paid to win, okay? And if winning is to effectively discredit your testimony, it's your testimony they want to discredit, not necessarily you. And so you can't take that personally. You just really do the best job you can to make sure that what you say is really the truth, and therefore really kind of hard to discredit.
I think what you said, Hoyt, is worth underscoring, because it gives you, to the extent that you end up working with lawyers and the clients directly, you need to have a sense of the pressure that they're under. And litigation is literally war. Somebody is going to win and somebody is going to lose. And nobody ever wants to be the one who loses. It's just a terrible thing. So it's bad in a lot of different ways. So the expert can be really critical, and you need to keep that in mind when you deal with the attorney and when you deal with the client, that these people are under a great deal of stress, that it's very nice for you to show up and help. And yes, maybe you're the batter that's going to come in and win the day, but they've been living at this for a long time. And
it's like you said, I remember, and you talk about spoliation. The interesting thing about spoliation, of course, is that the lawyer themselves can actually be hit with penalties by the judge for spoliation. So lawyers tend to take spoliation cases very, very seriously. And when I showed up, you were the opposite of relaxed. because because as you said, you had this was you were the third person on this case. You had nothing to do with the preparation of evidence, and yet if there's any problem with the evidence production and any spoliation thing would have fallen on you, and there's a lot of pressure. So when you're an expert, you kind of really have to recognize this pressure, and that's why I keep using this word equanimity. If anyone knows me, has met me, I am quite passionate. I'm yelling at Lauren all the time over the strangest things. Okay. But that's just
exploding tar balls.
Exactly. That's just the way I am. But I go in an absolute total different mode when I'm in the witness box or when I'm being deposed. My hands don't fidget. I rest my hands and I do everything very considerately. I just make sure I answer things correctly. And the other thing that I'll tell you one thing I am very bad at, the lawyers yell at me, is that lawyers would like to be able to object. And sometimes I answer a question too fast. And so they keep telling me, and you should remember the saying, if they ask you a question, take a beat, then answer. Give your lawyer time to say, I object, okay? Don't just do it like me. I get into this dialogue with the opposing counsel, and I'm not worried about it, but still, the attorney that I'm working for would really like to get their objections on record, and I'm not helping them. So
let me interject now. There's a couple more questions, if you don't mind.
Yeah.
For instance, lately, what areas of technical expertise and security are you finding coming up in your cases, such as data security, networking security, et cetera?
That's bizarre for me. Yeah, it's bizarre for me because I do more than just security, because obviously I had a big battle about APIs. I mean, I actually started in security because I was interested in distributed processing. You have to secure it. The two things that I've gotten involved to with that really had to do with security and cryptography. One of them I've mentioned, okay, which was this entire key escrow thing. You know, if you're going to encrypt, you better be doing key escrow. You better be doing it right. And another one was a Markman having to do with a patent case, and it was all on timestamping and hash chains and so forth along those lines. And so done that. But other things have just been based on my knowledge, the fact that I've actually been in, quote, information processing in distributed systems. And in fact, even though I did X509, I really was an OSI person. And so, you know, 7 layers you guys complain about, I led the effort on layer number 6, presentation layer. You can blame ASN1 on me. And well, actually on an Englishman. But anyway,
Can we take one more question?
One more question. Yeah.
How do you get yourself visible to attorneys as potential expert witnesses to start the journey? I'll start the answer because Hoyt will probably finish it. Frankly, Google is a friend for me. I have found expert witnesses starting that way because some of the areas that I'm looking for are really unique. So it may not be something that it may be something that a position that they formerly held. I remember looking for some, or it may be something that they've published. Publishing, I'm tending to stay away from that more, depending on the nature of the expert I'm looking for. I'm looking for somebody with more hands-on practical experience. So the nature of the positions they have held are helpful. I see Hoyt has a point.
Well, actually, I'm going to tell you we're out of time. But anyway, hang with lawyers. That's the major point. You know, wherever they are, hang with them. Go to panels. That's the way it works. And by my clock, we are out of time. So let me tell you, I got the Arizona testimony case, not because of me, but because a guy in my company in Phoenix, Arizona, went to a local session, local presentation. I don't even know what they were talking about, okay? But one of the people on the panel with him was a lawyer. And when that lawyer was hired by the state of Arizona to handle this case, he called this guy who's worked together and said, who do you know who might be an expert witness in this area? And this person actually happens to be my fearless leader, Jacques. Jacques says, well, I know someone close to hand. And so I was introduced. So just that kind of thing. It can be your friends going out and doing it.
I'm sorry, I just want to, so wait, I think you froze.
No, I haven't.
Okay, I just want to be clear to restate my answer. Google will bring up LinkedIn connections as well. So when I say Google something, it's because so LinkedIn is subsumed in it. So I just want to be clear about that.
Oh, yes. And you're not advertising Google. Yes.
And I'm not advertising LinkedIn.
It's like Kleenex or Coca-Cola. I do not sell Coke products. Okay. Trademarks.
Well, thank you, everyone.
Yeah, right. It's been swell. At least I hope you think it's swell.